Good morning to Chair and good morning to all the members and the department. Chair, today we have the following members. We have yourself, Chair, Junjua. We've got Honorable Zuma. We've got Honorable Kado, Adrian, Honorable Yinana, Honorable Ngobo, Honorable Denner, Chair, so far. And then, Chair, from the staff, we've got myself, Ella, thank you, Chair. The only Chair, same as last week, Mr. Andrew and DG. Thank you.
Sorry, Chair. Zolani is breaking up a bit. Maybe put the picture off. Sorry.
Yes, that's what I was also going to say to him, that there's something seriously wrong with his network. I couldn't really pick up what he was saying.
Okay, Chair, maybe let me start. I was saying, Chair, from the Portfolio Committee, we've got yourself, Chair, Honorable Junjwa, Honorable Zuma, Honorable Vormarans, Honorable Kado, Honorable Begram, Honorable Hinana, Honorable Ngobo, and Honorable Denner. We also have from our support staff, myself, Koshia, Folelwa, Tibomseni, Tebu Komkwena, Mr. Mavalukani from the Parliamentary Communication Office. And then we also have now Mr. Honorable Nonsele joining in. We have an apology from last week, the Minister and the DG Chair. I see the Honorable DM is also joining in. Thank you, Chair.
No, thank you very much. I see that we have also been joined by Mr. Hendricks, Honorable Hendricks. Good morning, sir.
Oh, yeah.
Good morning, Honorable Chair. It's a pleasure for me to join today.
Good morning. Good morning. I see a hand up. Honorable Mkondo.
Good morning, Chair. I'm also here. I did not hear Mr. Sagazan mentioning my name. Thank you.
Oh, my apology, Chair. Sorry, I didn't see.
Yeah, because I also was wondering what was happening. Maybe it's the issue of the network. No, thank you very much, honorable members. Do we have any guests? Oh, from the good morning, honorable GM, from the department, who's around? Oh, you have also indicated that we have also been joined. I'm not quite sure whether who is going to be leading the presentation, but I just want to, before I give the DM, if she will have any brief overview. I thought it is important, honorable members, that I just briefly take you through on this. Can I say maybe a bit? I don't want to say unusual. I received like any other member of the public who will send an email to any member and to the chair included in that, from a person called Mr. Manafana, if I'm not mistaken. And upon reading this correspondence, I picked up that it really got some issues that I would think that it will be important for the department just to, before we then engage in other processes, for the department to just take us through on that, because among other things is that there is a mention of a concord on this matter. And then I felt that it will then be very important that the department just take us through on this matter, which is a matter that is one of the very serious, all matters that are affecting employer-employees at the workplace are of very importance, and the issue of the employment equity. Because this gentleman is, I think, where the department is taking us through, and I think members received that correspondence. What I think it's important is that maybe members will pick up a little bit. I don't want to say an anomaly, that we have not been exposed to a proposed amendment for now. So after the department has taken us through, because the only thing that we're not going to be deliberating anything today. We're going to hear what the department is saying in relation to its work, and in relation to, are they aware? If then they were aware, what is it? Blah blah blah, and then we just ask questions, and after that, we will then, at the due course, announce what is then we are then going to do in relation to this, because it's, and you will remember, members, that any person in the Republic of South Africa has a right to submit whatever he or she wants to submit to Parliament. In this case, is a bill, and Parliament will then engage in its processes upon receiving that. So I thought it's important for members to really have that understanding that now we were called to a meeting, there's a correspondence. What it is because of that background. DM, is there any overview before I give to Honorable?
Good morning to you, Honorable Chairperson, and good morning to honorable members and our officials. I don't want to underscore our presentation, Honorable Chairperson. I would request that if you allow that we go straight to Mr. Mkhaliphi to present that which the department has gathered, so that then we give more time to honorable members to deliberate on the matter itself. But I wouldn't want to preempt what the department will be presenting this morning. Thank you so much, honorable members and honorable Chairperson.
Members, Honorable Mkondo, I'm sorry. Mr. Mkhaliphi is going to take us through. Today is just questions of clarity, if there are any, and then from there we then move after being clarified on some of the issues that we'd like to be clarified on as members, because basically this was supposed to be our members with the department, obviously led by the executive authority and the office of the DG. I will hand over to you, Mr. Mkondo, Mr. Mkhaliphi.
Thank you, Chair, and DM and honorable members. My colleague, I'm with my colleague Ntswaki Mamashela. We are going to share the presentation. I'm going to do the first 3 slides, and then she will do the bulk of the slides, and then I'll come back on the last slides, and then we'll share also in answering the questions. Ntswaki, can you fly to the presentation?
I'm trying to fly. I'm trying to fly, Mr. Mkhaliphi. Sorry, Chair.
Sorry, ma'am. Mr. Sakaza, I see names here, and those people have not introduced themselves. Can they do that before we start? I'm not quite sure. I see Mr. Ostazen. I'm not quite sure whether it's from the department. And can they please introduce themselves and tell us where they are coming from? And Patu Makavana, can they please introduce themselves, because that's what we do in the committee. You just tell us who you are and from which organization you are coming from.
Good morning, Honorable Chairperson, and good morning to the honorable members of this committee. My name is Patu Makavana. I am from a campaign called paymefairly.org. Thank you.
Okay. And Mr. Oosthuizen?
Hello.
Good morning, Honorable Chair. Good morning, honorable members. I am merely a researcher from the Democratic Alliance.
Oh, okay. Okay. Thank you. All right, Mr. Mkalipi, over to you.
Sorry, Chair, through you, Chair. There's also Mr. Bota Singh. I don't know who. Bota Singh. Bota Singh.
Thank you, Chair. Good morning to the members and to yourself, Chair. My name is Adira Bodasing, and I'm also with paymefairly.org.
Thank you. Thank you. Over to you, Mr. Mkalipi.
Ntswaki, are you succeeding?
Mr. Mkabi, I'm trying to share. Can you see the presentation?
Not yet. We see your name.
You still can't see it?
No.
Chair, can we request Mr. our secretariat at the portfolio committee to help us share? It looks like I'm struggling from my side, Chair. Apologies.
Okay. Mr. Sakaza, can you assist? May I assist on that? Is it?
I'm trying to, Mr. Honorable Chair, but Mr. Mkalipi must take off his, because he's also now trying to share.
Okay, I've taken it off.
Okay, let's go. Can you see it, Chair?
Yes, we can.
Yes, we can.
Put it on, put it on slideshow, please.
Where is that now?
Yes, you are on the right one. Click that one. Thank you.
Thank you.
Thank you.
Honorable members, can you move then, Mr. Sakaza, to our slides? Our slides are going to deal with the response is divided into two. Our slides will see are divided into two. On the left is the case that is made by Mr. Patuxolo Makavana. On the right, it's our response on the slides. That's the format of the slides. And we're gonna deal with his case and then go on the legal framework on equal pay. We are gonna deal with international obligations. We are gonna deal with the constitution and the guarantees in the constitutions of our country. And then we'll go on the Employment Equity Act 2013, 2014, the regulation of 2014. And then we'll go into the Code of Good Practice that was published in 2015 on equal pay, just to unpack these issues. Next slide, please. As I've indicated, honorable members, on the left, I'm not going to deal with the left. I'm hoping that honorable members have read what Mr. McGovern in his input is saying. The case that Mr. McGovern is making is that first issue that we need to indicate is that he is saying that this case has gone up to the Labor Court and the Constitutional Court. We've tried to check what are the cases, and we can find out in November 2016. And also the other issue that we need to explain is that in his input is that he is asking the members of parliament to pass a law that will allow or disallow employers to ask for a pay slip when they employ a person in a job. That's the essence of his case. But then when we check what were the decisions of the courts in this case, we find out that he went to the CCMA in 2016 and referred a case on unfair discrimination to the CCMA, where he alleged that he received lesser pay than his colleague, who was a white female, who was also a merchandiser like him. That the essence of the case that he took to the CCMA. At the CCMA, it's not about the pay slip that in the submission that he has made to talk about. It's about issues of equal pay and discrimination. And an arbitration award was issued on this effect on the 31st of August in 2017. And the commissioner dismissed the case. Therefore, Mr. McGovern lost the case. And the reason he lost the case, the commissioner said there was no evidence whatsoever of race playing a role in the difference in wages, because the commissioner found out that there was evidence laid that shows that there were black men who are as black as Mr. McGovern, who earn more than Mr. McGovern and earn more than Mrs. Mills, who was a white female. Therefore, it's not a matter that the company is discriminating against black men or black female and giving white females more money than black men, as Mr. McGovern alleged in his arbitration, because there is other black men who are earning more than him. That's what the arbitrator find out. And the arbitrator find out that, therefore, on the balance of probabilities, they cannot find and that discrimination took place. And the arbitrator felt that the decision taken were rational and fair, and therefore Mr. McGovern lost the case on those bases. Next slide, please. Now, he then went back to the CCMA and raising matters of another unfair discrimination in pay based on arbitrary grounds this time. Remember the first case was on discrimination. The second case that now he lodged on the 20th of November is based on arbitrary ground in terms of the employment equity. At the CCMA, the company raised points in legal issues, pointing out that the case was heard, it's similar case, it's same issues that are being raised with the previous case. Therefore, the CCMA cannot hear this case again. As a result of that, the CCMA agreed with the company that they can't hear the case. Then Mr. McGovern went to the Labor Court, challenging that decision of the CCMA of refusing to hear the case on the basis that it's the same case that was heard in 2017. In the Labor Court also made a ruling in this case, rejecting Mr. McGovern's allegation that the commissioner in not hearing the case, because he was challenging the rule that was made by the commissioner. And the Labor Court, on the basis of the evidence that was presented, also agreed that the CCMA had no authority to hear a similar case that was put by Mr. Makavana. Now we check with the Labor Appeal Court. There was no case in the Labor Appeal Court under his name. In the Constitutional Court, there was no case in the Constitutional Court. Therefore, we don't know what case is he talking about in his papers when he talks about a Constitutional Court decision. Next slide, please. Now, it is important, members, to highlight that the Employment Equity Act that was amended in 2013 deal with these issues and in terms of how to deal with cases of discrimination, cases of equal pay for work of equal value. The Code of Good Practice deals with these issues, and the code gives guidelines on how CCMA and employers should deal with this. And the Act in Section 5 of the Act also explain what employers as legal obligation in terms of taking steps to promote equal opportunity by making sure that there's no unfair discrimination in the workplace, including ensuring that pay and remuneration policies are fair and are not discriminatory. Now, in light of the above, if an employer asks for a pay slip and the salary history, and they make a decision that discriminate on the basis of the salary slip, you can take up a case on the basis of the discrimination on unfairly on the issue of equal pay. He's got a right to do that. Now, our colleague Ntswaki Mamashela will take you through on the law and how these policies operate and how can they assist in a case like this. Next slide, Ntswaki, you can take over.
Thank you very much, Mr. Mkaripi. Good morning, Honorable Chair and honorable members of the committee, our DM and senior management of the Department of Employment and Labor. Honorable Chair, I first need to explain that as a country, we have ratified the ILO Convention 100. This convention actually deals with equal remuneration for work of equal value. And we have ratified this in 2000. And since 2000, every second year, we are required by the ILO to submit a progress country report, explaining what we have done as a country to ensure that the principle of equal pay for work of equal value is actually implemented and enforced in our country. Because as ratifying members, we have a legal obligation to ensure that our laws, our national laws, complies with the requirements of this convention. And since 2000, we had challenges every time we got feedback on the country report that we submitted at the ILO, that the ILO Committee of Experts always expressed that we did not have specific provisions in our Employment Equity Act that speaks to the principle of equal pay. And we argued all the time that the Employment Equity Act itself, in particular Section 5, is very clear that employers must take the necessary steps to actually eliminate all forms of unfair discrimination in employment policies and practices. However, because we wanted to comply fully with Convention 100 that we ratified, the department took a decision in 2013 to amend the Employment Equity Act to include specific provisions that speaks on equal pay. And since we amended the Employment Equity Act in 2013, honorable members, is that the Committee of Experts have expressed satisfaction that we fully comply with the provisions of the ILO Convention. Next slide. In the next slides, honorable members, I want to outline first the fact that we have the Constitution, which we believe that covers the issues of equality adequately on Section 9. And if we look specifically on Section 9.3 of the Constitution, it requires that the state may not unfairly discriminate against anyone on the basis of the different prohibited grounds, including race, gender, sex, pregnancy, and religion, all those that are listed in the Constitution under Section 9.3. And furthermore, Section 9.4 says that there must be national legislation that is enacted to prevent or prohibit unfair discrimination. And as a result of the provisions of the Constitution or the Equality Clause, we now have a specific dedicated section or Chapter 2 of the Employment Equity Act. In particular, I've already alluded to Section 5 that requires that all employers must take positive steps to ensure that they eliminate discrimination in their employment policies and practices. Employment policies are all human resource policies and practices that deals with terms and conditions of employment, inclusive of remuneration, wages, pay, and benefit packages that are paid to workers or employees. And taking the tune from the Equality Clause in the Constitution, we then unpacked further the Employment Equity Amendment Act provisions to make sure that we are fully aligned not only to the constitutional guarantees, but also to the ILO Convention 100 that deals with equal pay for work of equal value. We can move to the next slide. In the next slide, honorable members, I'm just specifying the provisions that were included in the amendments of 2013. In the amendments of 2013, we made sure that we unpack further Section 6.1 of the Employment Equity Act that prohibits unfair discrimination directly or indirectly on the different grounds. And you will see there that we also added that no one or no employer must unfairly discriminate on all the listed grounds, inclusive now of a new ground on arbitrary ground. We all know that an arbitrary ground must also be linked back to the listed grounds such as race, gender. At times, the arbitrary ground employees understand what it means. Arbitrary ground is any of the grounds that are not listed, which may be used by employers to discriminate their employees. For example, I'm an African woman. I'm not a light-skinned African woman. I'm dark in my features. And you might find that they might use the fact that I'm dark, I'm short, I'm not tall. And in the listed grounds, the darkness of my skin, although I'm African, is not part of the listed, although there is color there, the color doesn't differentiate how light your skin is or dark your skin is, or how tall or short you are. So some of the arbitrary ground, you need to link back to the listed ground. I need to argue that I'm paid differently from other African women because I'm shorter, I'm too dark, others are light-skinned, although we are all African women. I'm just making an example. And if you look again in 2013, we had a specific provision, Section 4, which was never in the Employment Equity Act, where it deals with the difference in terms and conditions of employment between employees of the same employer performing the same or substantially the same work or work of equal value. What this provision means that you cannot, or an employer cannot unfairly discriminate a person or an employee doing work of the same value or work of equal value, or the work should be substantially the same. At times, we know there are different titles that are used by employers, but the work is substantially the same or work is of equal value. In the hospitality sector, if you are a woman, they refer to you, for example, as a cook. If it's a male person doing the cooking, they say a chef. And at times they use the titles to actually pay different salaries and benefits to employees. And the law says now you cannot do that where work is of equal value or substantially the same. And if you look again on the provision 6.5, it explains that the minister, after consultation with the Commission for Employment Equity, must prescribe a criteria and methodology on how employers should assess work of equal value or work that is substantially the same, as long as those people or employees are working for the same employer. What is important here, you cannot compare your salary that you are earning in one employer's establishment to another one, which is a different employer. You must compare your work of equal value to an employee or a colleague that is employed by the same employer. Next slide. In the next slide, honorable members, in order to make sure that the provisions of the Amendment Act of 2013 provide implementation guidelines to employers and employees so that they are able in their own workplaces to implement the principle of equal pay for work of equal value. There were regulations in 2014 that were developed and published by the Minister of Employment and Labor to ensure that we unpack the provisions of equal pay that is in the Act to ensure that is properly implemented. I'll go straight to the Regulation 3 that is in the EE regulations of 2014. In this Regulation 3, we further unpack to make sure that employers understand that they need to eliminate unfair discrimination in pay, wages, and benefits packages that they pay. And in this regulation, we explain that employers are required to take steps to eliminate any unfair discrimination that can appear in terms and conditions of employment, including remuneration. And they should make sure that they are not unfairly or discriminating employees in pay and benefits based on any of the elements that are listed under Section 6.1 of the Act. And we also explained that the employer must ensure that employees are not paid different remuneration for work of equal value based on race, gender, or disability, but also on all the different listed grounds under Section 6.1 of the Act. Here, I've just lifted race, gender, and disability because these are vulnerable groups that we know that are outlined in the Employment Equity Act. Previously, Black people, women were discriminated because of their gender, and persons with disability were also treated unfairly based on their different types of disabilities. The next slide. Regulation 4 then actually unpacks what is the meaning of work of equal value. In the regulations, we explain that for the purpose of implementing equal pay for work of equal value, we need to actually look at the different meanings of what work of equal value actually means. Work of equal value performed by employees, it must be the same as the work of another employee of the same employer. I've already alluded to that. And in some instances, the work is identical or interchangeable. In some organizations, we utilize receptionists as the front desk people that receive customers or clients that enter the workplace. And in the same instances, you'll find that a secretary is being used as a receptionist. So in that scenario, the work is interchangeable. Although the title might be secretary, the other title might be a receptionist. In those instances, those people must be paid equal pay because the work is identical or interchangeable whenever the employer wants to utilize the employee. Again, the work must be substantially the same as the work of another employee employed by the same employer. if the work performed by the employee is sufficiently similar, that they can reasonably be considered to be performing the same job, even if their work is not identical or interchangeable. In the public service, I'm giving an example. You'll find that there are different titles that we give people. We call people office administrators, and they serve also as secretaries. And when it's a male doing a similar job, we call them practitioners. And although at times the work is not interchangeable because the practitioner might be working in finance or working at supply chain, you'll find that the office administrator also does more or less work of the same value. When the job evaluation is actually conducted, you'll find the value of the job done by the practitioner and office administrator, the value is the same. And in that case, the law says they should be paid equal pay, and the benefit packages must be the same. The last area that the regulations also highlight is that the work of an employee is of the same value as the work of another employee of the same employer in a different job, if their respective occupations are accorded the same value. I've already alluded to the fact that the titles might be the same, might be different. The people might be placed in different units in the public service. But however, when a proper job evaluation system or a grading system is applied, the value of the job is the same, and they are working for the same employer. Therefore, there shouldn't be any differences in terms of the pay or wages that are paid and the benefits that are paid to a practitioner in supply chain and an office administrator that is servicing the office of a DG or an office of a director. Next slide. Also in Regulation 5, we actually unpack the methodology. We link this to the provision 6.5 of the Employment Equity Amendment Act of 2013, where the Minister of Employment of Labor, after consultation with the Commission for Employment Equity, must prescribe a criteria and a methodology to be utilized by employers when they deal with work of equal pay. So equal value. So in Regulation 5, the methodology has been prescribed to ensure that we align to the provisions of the Act. It actually prescribed that employers, when they assess the value of the job, they must apply this methodology. First, they must actually establish whether the work consent is of equal value in accordance with Regulation 6. I'll go to Regulation 6 now, which actually gives the criteria that needs to be unpacked. And secondly, they must then assess whether there is a difference in terms and conditions of employment. If a person is a practitioner in supply chain and this one is an office administrator, they need to first establish if the work is of equal value. Secondly, they must check if currently there are any differences in terms and conditions of employment, including pay that is paid for a practitioner in supply chain and office administrator that is servicing the director in an office, in a different office, although employed by the same employer. Further, it must be established whether any difference in terms of sub-regulation 1B constitutes unfair discrimination. After you look at the value of the job and checking if there are any differences, you need to check if there is any unfairness in the terms and conditions of the two positions. I use the practitioner and office administrator as examples in this case. In the next Regulation 6, if we move to the next slide, honorable members, we need to look at a criteria. This is the criteria that is in the regulation. And it's very important that we understand that in a job evaluation, to determine or assess whether work is of equal value, the criteria must follow these 4 areas, which are very important. And as we did our research when we were developing this criteria, we realized that this is a global norm, that this is the criteria that is utilized by different countries that have ratified the ILO Convention 100. And also when we sent our draft regulations to the ILO, they confirmed that the criteria is in line with the international norm. That first, for you to be able to assess whether work is of equal value, you need to first determine the responsibility demanded of the work, including responsibility for people, finances, and material. We need here, when we talk about the responsibility demanded of the work, we are looking at the span of work. What is your responsibility in relation to managing the budget, managing people? What is your staff establishment, the complement, how many people are reporting to you? What is required in terms of performing your work in relation to quality as well, and the quantity of issues that you are dealing with. And again, we then look at skills, qualifications, including prior learning and experience required to perform the work. This is very important because at times, the skills, qualifications, people say we use skills and qualifications to unfairly discriminate those people that didn't have equal opportunities to go to school. But the inherent requirements of the different jobs dictates the kind of qualifications and skills and prior learning or experience required for the person. So this is a second criteria that must be taken into account. The physical, mental, and emotional effort required to perform the work. We know that at times, certain work like policy work, like research, I'm giving an example, and also finance, you need to understand maths. You need to be able to understand accounting principles. It takes a lot on your mental capability and emotional effort to do the job. At times, some construction work also requires a person to be physically fit, or also if you are in defense or in security offices, like in the SAPS, you must be physically fit so that you are able to perform your job as a police person. And also emotionally, you must be emotionally fit to be a caring person, to do work as a doctor or as a nurse or as a social work, so that you are able to do the work. The other area which is important when you do job evaluation in terms of criteria, you need to look at the conditions under which work is performed, whether physical environment, psychological conditions, time required to do the job, and geographical location. In this area, we all know that in some instances in the mining sector, you need to be able to go down in the mine. Therefore, you must be physically fit, emotionally fit, mentally fit, and psychologically as well. You are not going to be able to be a social worker if you are psychologically not fit. You are not going to be able to assist people that come to you for counseling, care, and support if you yourself, you are not psychologically fit. And the geographical location as well, employers are required to give an allowance to people that maybe work in rural areas where they have no access to electricity, access to running water. I'm just giving an example. Normally they get an allowance so that they are able to actually complement their salary to be able to go and buy water or be able to buy other fuel for a generator because they have no access to electricity. So those are issues and elements that actually determine whether the work is of equal value or the work dictates that is of equal pay. In the next slide, Chair, I'm about to just summarize all the slides now so that I don't take too much time of the committee. In the next slides, Chair, it also still continues with the criteria that you need to take into account when you're assessing work of equal value. you also need to look there at other factors indicating the value of the work, which are relevant, of course, to the value of the work. And in some cases, they also throw in there that if you work as a rock driller under the mine, it's a relevant factor that because it needs physical strength to actually do the job. So it's another factor that can also go into the value of the job. However, whatever criteria or a factor that must be taken into account, it must be in a manner that is free from bias. It must not be based on race, gender, or disability, or any other of the listed grounds. And also, if there is a difference why you are giving different value to the jobs, the employer must be able to justify the value assigned to an employee's work and must make sure that there is a reference to the classification of relevant jobs in terms of a sectoral determination. If there is a difference in pay, and this is informed by a sectoral determination that has been made under the BCA, and the employer cannot change the classification of that job because the sectoral determination made by the Minister of Employment and Labor and the BCA has already classified the job, then that is not an unfair discrimination. We all know that we have different sectoral determinations issued by the BCA for farm workers, for domestic workers, and in the farm workers determination, Chair, there are different classifications for what the value of a truck driver is, the value of a person that actually drives a truck in the farm. So the job has already been graded and classified under sectoral determination. Therefore, the employer cannot now go against what is already been classified. I'm just giving an example in relation to classification of the different jobs. In the next slide, Chair, we have different factors that employers can use in relation to justifying differentiation in terms and conditions of employment. And this is very important because it's also an international norm when we did the research also with ILO, is that in cases where a person is a director, they are all, I'm giving an example, they are all Africans, African males, for example, they are working for Department of Labor, there will be differentiation in salary because they may not have started in the employment of the department at the same time. Therefore, the difference in salary will also be based on seniority or length of service as a director. I'm giving an example, or as an admin clerk. Therefore, length of service becomes a justifiable reason for differentiation in pay and benefits. Because the longer you have been a director, you have received the different pay progressions based on your performance. Therefore, the salaries will not be the same. The second area that can justify differentiation in salaries is qualifications, ability, competency, and then as required to do the performance of the job. We all know at times that people go into a job based on the fact that they were promoted because they've been long in the job, and then comes someone with a higher qualification, which is now being dictated for that particular position. And because they have different qualifications that are linked to the inherent requirements of the job, and the ability also to do the job is different given what is required by the job, you'll find that there will be differentiation in pay paid to those people. Other people come, they negotiate that I'm a director from where I'm coming from, I'm on a second notch, and this one is just entering a director position, is at an entry level, and based on the expertise that I'm bringing, I then request to be put on a third notch of a director. And this is based on the competencies required. Therefore, there's nothing wrong with that. Another area is performance, quantity or quality of work related to the job. And this is based on performance management or performance evaluation systems that must be consistently applied by the employer, and it should not discriminate. There are people that come to work, do their work, they earn their salary, they do nothing outstanding. And on performance reviews, you'll find that others are outstanding performers, and they, based on their performance, they therefore qualify to actually move a notch higher. And therefore, there's no discrimination. It's based on performance after a proper performance evaluation system has been applied. And other areas in the next slide that also justify, Chair, right or wrong, these are international justification factors that are being utilized. At times, a person is demoted from being a director to a deputy director. However, their salaries are not taken away or are not reduced, because at times it will be unfair labor practice to reduce a person's salary when you demote them. Therefore, they are now working as deputy directors. They are still earning the director salary. However, they are now creating an anomaly in pay with other deputy directors that are at an SR12 level. And the law says there's nothing wrong to cap the salary of a demoted person at an entry level of a director if they were earning that at that level. And you fix the salary in such a way that the other deputy directors that are earning lower than what the demoted employees earning should catch up. It's also a justifiable reason to actually do that. And it justifies why there is a gap between other deputy directors and a person that has been demoted. Another area also, we take people on learnerships for experience or for training or internship, so that we expose them to the work environment so that they can get a work experience. They can come in as learnerships at the assistant director level. However, they may not necessarily be paid the same as assistant directors that are permanent, because they are on internship or on a learnership. That is also a justifiable reason. At times, we actually headhunt people based on the shortage of the relevant skill that we require. And as such, the market dictates how much you must pay for that skill that is in shortage. We all know that in most areas, we don't have enough civil engineers, or we don't have enough electrical engineers. The few that you actually poach or headhunt, they come at a premium because of the market forces that pushes their salaries up. We all know the issues of demand and supply. If you are in demand, your skill is in demand, you'll also have a higher market value. Therefore, your salary might be higher than those that are in the employment of the employer. Therefore, because you have been headhunted, you'll be paid higher because of the shortage of skill. And that creates an anomaly in terms of salaries. And in the next slide, honorable members, I'm moving quickly to the Code of Good Practice, which was further developed and published in June 2015. In this code, we are also providing practical guidance to employers and employees, but we are also giving best practice, which was picked up internationally in other countries as well. And the objectives of the code is to give employers the best practice and practical guidance, and also to ensure that human resource policies and practices on remuneration and benefits packages are aligned to the law, to the Employment Equity Act, and are also aligned to the regulation to ensure that there's no unfair discrimination. In particular, we focus on job evaluation processes to ensure that there are sound governance frameworks in employment, and to make sure that salaries are equitable, fair, free from unfair discrimination, and whatever job evaluation criteria is adopted by the employer, it must be consistently applied, irrespective of whether you are Black, you are a woman, you have a disability, or you are married, or you are coming from a different religious background. I'm just mentioning some of the listed grounds that are in the Constitution and the Employment Equity Act. In the next slide, you'll see that the code further unpacks chairperson and members. If we move say to the next slide. In the next slide, we also in the code give some guidelines to employers how to compare and evaluate male and female dominated jobs. Earlier on, I've explained that in most cases, and also the ILO has provided some guidance here, that previously, also in South Africa, the female dominated jobs have been undervalued compared to the male dominated jobs. So the code actually unpacks that there are jobs that employers must actually check, which are female dominated, which have been undervalued because of stereotypes. And we have given example that we all know that the nursing profession is female dominated, and social work, and it has been undervalued. If you, based on the fact that most female dominated jobs were not properly evaluated based on gender. And at times, employers also, based on traditional job evaluation methods, the male dominated jobs, for example, mechanics or those jobs in construction, are accorded a high value compared to the female dominated jobs like nursing and social work. However, if you look at the criteria of the demand of the job, the mental, the psychological, emotional effort required to do the job, you might find that there's been unfairness in according the value of the job because it was based on gender stereotypes or traditional job evaluation methods. And in that regard, employers need to then reevaluate those jobs and give them the value that is not discriminatory based on gender. And other issues is that we find that in domestic worker sector, there is weaker bargaining power. We know that it's difficult for domestic workers to organize themselves because they work in our private homes. And normally, the value of their work has always been undervalued. And it's time that we all work together to make sure that we accord the value of the job done by domestic workers and people that care for the sick people in our homes, to ensure that the value is in accordance with what is required by the job market and not based on stereotypes. And therefore, in that regard, the code requires that employers must actually start doing proper job evaluations to look at the female dominated jobs that were undervalued and try and align them to the value of the jobs accorded to the male dominated jobs. Lastly, Chair, I'm looking at a job evaluation process in the next slide before I hand over to Mr. Mkalipi to wrap up. The next slide talks to the factors justifying differentiation. We further unpack them in the code of good practice and provide the best practices, but it must be clarified that whatever justification reason that the employer gives for differentiating in relation to pay, it must be fair and rational. And it must actually, if you say it's length of service or its qualifications or performance, the burden is on the employer to indicate that a fair and rational performance evaluation system was applied. or when we deal with qualifications, you're asking everybody that is applying for the job to provide the same qualifications, and there is no differentiation based on race, gender, or marital status, disability, or any of the prohibited grounds. In the next slide, Mr. Sakaza, the job evaluation. Chair, the Code of Good Practice unpacks and gives proper guidance to employers how to do their job evaluations to determine equal pay for work of equal value. And I want to zoom into the fourth bullet. I know in the letters coming or the petition from Mr. Makavana, there was an issue where he alluded to the fact that the bill that he's proposing must deal with employers that are not having job evaluations that are fair and transparent. In the Code of Good Practice, honorable members, the guidance is already provided that whatever job evaluation criteria or methodology is followed by the employer in job evaluation or in grading systems, it must be fair and transparent and does not have any, the employer must make sure that it does not have the effect of discriminating unfairly based on any of the listed or any of the arbitrary ground. Therefore, the issue of fairness and transparency in job evaluations and grading systems has already been covered or regulated by the existing national laws. And if you have been unfairly discriminated because the job evaluation or the job grading system you believe was not fair and transparent, then you are able to take your case to the CCMA or the labor court so that they can determine whether the job evaluation was unfairly discriminatory against you and there was no transparency in dealing with the value of the job so that there is equal pay for work of equal value. In the next slide, which is my last slide, Chairperson, it goes further also that when you do job evaluation and the method that you select to compare jobs must also include money and payment in kind. We all know that in sectors such as domestic work and farm workers sector, employees are not always paid in money, in monetary value. At times they are paid in kind. They are instead of getting wages, they might be getting a bag of meal to supplement the monetary salary. They might be getting a ration of vegetables. I'm just mentioning a few. However, when you do job evaluation, you cannot just assess the value of the job looking at monetary value and not the payment in kind as well. At times, people stay in our homes as domestic workers and we say to them, don't pay rent, you'll stay for free in the backyard, you are not gonna pay for water and electricity. That is payment in kind. That the value of the rent, the electricity, the water, and the accommodation that is provided must also be put as part of the job evaluation criteria. And also that the employers are required to always have a job or a remuneration or a workplace remuneration policy, which they must monitor and review depending whether they do it annually. In this code, we are advising that monitoring and review of your pay and benefit packages must be done annually. And why annually, Chair, is because Section 27, read with Section 21 of the Employment Equity Act, requires that on an annual basis, the employer must submit an employment equity report and to the Department of Labor. And in the employment equity report, the employer is required to also submit a report dealing with remuneration and benefit packages, whether there are any elements of unfair discrimination that has been identified and what measures has been implemented by the employer in relation to remuneration and benefits. It's part of the EA2 report that is being submitted by employers. The second report, Chair, that is being submitted annually is the income differentials report. Is an EA4 report that is submitted by designated employers. And in this report, employers are required by Section 27 of the law to submit to the department, the Director General of the Department of Labor, on income differentials that they have identified across all occupational levels, starting from top management to unskilled level in terms of race and gender. If they are paying any salaries that actually discriminates or unfairly discriminates based on any of the listed grounds. We all know, Chair, that is difficult in South Africa based on our historical history, that we can close the gap between the highest paid employees and the lowest paid, given the fact that the laws that were in place in apartheid era discriminated not only in terms of conditions of work, but also in wages. And in most cases, as we look at the income differential statement, you'll find that there is still differences in pay between whites and Black people, between males and females. And now the National Minimum Wage Commission is trying to analyze the data that is being submitted to actually advise how we actually close the gap between the highest paid and the lowest paid. I thank you, Chairperson, for the opportunity to present. Mr. Mkalpi, you can take the next slides. Thank you very much.
Thank you, Tswaki. Move your next slide, please. In this slide, members, we're just asking 3 questions. This proposal to have a law that is called the Fair Wage Law that bans basically employers from asking a pay slip. Who is it benefiting? Who are the beneficiary of this law? In our view, it's not going to benefit the unemployed. Maybe the employed, yes, because the unemployed, if a person who's unemployed is given an offer to be paid 50 Rand an hour, they are likely to accept that offer. Only people who are moving from one job to the next job would negotiate with their employer and want more. Now, next question that we're asking is, what are the unintended consequences to those beneficiaries of a bill like that? Now, if an employer offers an employee, I work for company A, I apply for a job in company B. Company A, B offer me 100 Rand an hour. And I say to company B, no, I cannot accept 100 Rand an hour because I'm already earning more from the company that I'm working for. And then company B says, well, prove that you are earning more. If now we ban payslip, how is this employee going to prove that they are earning more from company A that they are moving from? Because the only thing that is credible that you can produce is your payslip that will be accepted by everybody. That's the first issue. Therefore, we think that this law would have unintended consequences which are negative to the people that are affected. Secondly, the other issue, honorable members, is that presently, the minimum wage, 40% of workers are not getting the minimum wage. That's a research that has been done by the University of Cape Town for the Minimum Wage Commission in reviewing this minimum wage. The issue is, how do you enforce this law? If you've got a law that says, don't ask for a pay slip, is that enforceable? How do you enforce a law like that? For us, these are the issues. Unfortunately, the bill that is mentioned in the submission, we didn't see the bill. We don't know how the bill covers these issues. Therefore, we can't speak on the bill. But we think that a bill like that is not going to do anything better for the unemployed. a bill like that is going to make it difficult for workers who want to move from one company to the other for them to negotiate. Now, if a company says, prove that you were earning what you say you were earning, and the employee brings a pay slip, is the employer allowed to look at that pay slip? Or is this law saying, don't even look at that pay slip because you're not supposed to look at that pay slip? Now, if the employer does look at the pay slip, what is the offense? How is it enforced? How do you enforce that the employer does not look at the pay slip? And what are the consequences of not looking at the pay slip? But the most important issue is, can you really enforce a law that says, don't consider a previous pay slip, especially when the employee themselves bring the pay slip to prove their case that they were earning more in the company that they are moving from. Thank you, honorable members. That's our presentation.
Thank you, Mr. Mkhaliphi. What now is we are going to do, honorable members, just to remind, is that it's only questions of clarity, and questions of clarity, if there are any, will only be asked by honorable members. So I want our guests to know that in whatever situation, they don't participate in these processes until there is a decision that is taken by the committee in its own time. So can I check any? I see one hand for now. I see one hand for now. 2 hands. Second hand. Third hand. Honorable Hendricks. Those are 3 hands. Questions of clarity. Don't debate. Don't argue. Just get questions of clarity from the department as they've presented. Thank you. Honorable Baker.
Thank you, Madam Chair. Thank you for the report and the feedback from the department. The feedback has been effectively a lecture on law, which is interesting for me, but I'm not sure why we as a committee needed to go through it. I don't think it added anything at the end of the day to the lecture for us as a committee, but for lawyers, that is interesting. I need to preface what I'm saying by saying that legislation itself, the employment equity legislation, I think is bad legislation, very much for the reason that Mr. Mkhaliphi said right at the end, that the unintended consequences are already here. We are almost at 40% unemployment in South Africa. And as Mr. Mkhaliphi said, of the 60% that are actually employed, 40% of them are not even getting the minimum wage. So the whole thing is, the workforce is being made a mockery of the whole thing, which doesn't make any sense. But I think that what we've had feedback from the department is not getting to the nub of the complaints. The nub of the complaints wasn't equal work for equal pay. The nub of the complaint was the arbitrary grounds.
Sorry, Mr. Pregram. Questions of clarity.
Yeah, I'm asking that. I'm asking for clarity. And I'm not finished. Can I go ahead?
Okay, continue.
Okay. So in essence, it's not that equal work, equal pay. What they wanted commentary on, and that's why I'm asking for clarity on it, is in fact the definition of arbitrary grounds, and also the definition of why the onus moves on to the employer as opposed to the employee to prove that the employee is not getting the money. So it's onus, the proof of onus, and the definition of arbitrary grounds, which I believe, if in fact we're going to have the legislation, there are hundreds of cases where arbitrary grounds has become a real problem, and I want some sort of clarity on what actually arbitrary grounds means. If we're talking law, what does it mean? Because every single judge has different reasons for arbitrary grounds. We are in fact in line with the ILO in terms of the legislation, some of the wording is very different, but we're in line. That's what we really need to look at, and wouldn't there be clarity on that, is the social engineering that we involved in. And also, to quote from Mr. McClippy, how do you implement it? Well, the simplest way for employers to do this would be to bring everyone's salary down to the lowest level, which would be silly as well. So I'm looking for clarity on those points. Thank you.
Honorable Mkhalipi, I'm sorry, Honorable.
Thanks, Chair. Thanks, Chair. Good morning to you, honorable members, the DM, and the department staff. Chair, based on the presentation, it is clear that there is enough legislation to deal with the matter. But I think, referring to this case specifically, the complainant was not able to put forth facts that would be able to prove his suspicions, because for now I will call it suspicions. So my question to the department is, because I think as an employee, the complainant has some limitations to prove exactly what is going on in that company. How was he supposed to be assisted, or how was he assisted by the department to go to the bottom of this matter? That is number one. Number two, those Black employees earning higher than the white female employee, are they doing the same job as the white lady? And is the white lady not discriminated against based on her gender? Because, Chair, I think complaints like this, the department must be able to assist, because the employee might not be in a position to request for the proof of all the things that have been presented to us today. So how is the department assisting if a complaint like this is brought forth? Thank you, Chair.
Thank you, Honorable Hendricks.
Thank you very much, Honorable Chair, and for this opportunity. Honorable Chair, I made a special effort to attend this meeting because I was really moved by the fact that the chair of this portfolio committee responded to a complaint by a member of the public, setting an example for all chairs that Parliament and members of Parliament are there for the public, and any complaint with some merits will be entertained. So I'd like to congratulate you, Honourable Chair, for putting this matter on the agenda, because pay for equal pay for work of equal value is as important as one man, one vote. I have been involved in pay parity cases, so I just felt that it was important for me to also try and assist the committee. And I'd like to thank the content people for their presentation. It was not a lecture on labor law. It was in pursuance of the grand objective of one man, one vote, and also with regard to the policy of the governing party that there should be pay parity. If you were correct, Honourable Chair, and here I want clarity, that our legislation doesn't make the cut, and that's why the International Labour Organization feels that more work needs to be done. There are problems with the regulations. there are problems with the code of good practice. And this was unpacked in a labor court case by Judge Steenkamp when he overturned a decision that was taken in the CCMA by Senior Commissioner Johnson, and he showed the defects in the law. So I would like to ask the Department of Labor if they are prepared to look at the judgment of Steenkamp, Judge Steenkamp, the late Judge Steenkamp, and then report back to the committee the anomalies that Judge Steenkamp found in the matter, and therefore overturned the decision of the senior commissioner with regard to the Pioneer Foods case, where two bread drivers were earning different salaries and obviously doing work of equal pay. There's only one way you deliver bread. There cannot be two ways to deliver bread. And why in this particular matter must the one driver get 20% more than the other driver? So, Honourable Chair, I feel it's very important for the Department of Labor to look at that particular judgment, because it will give this committee guidance on what changes it has to make to the Employment Equity Act, what changes it has to make to the regulations, which the Minister, unfortunately, at that time shouldn't have approved, and also the Code of Good Practice guidance to employers, but there is no real punch in that guidance, to motivate employers to promote the transformation in our country. So, Honourable Chair, thank you very much. I just hope I can get clarity whether they will look at the Steenkamp judgment, and maybe also the award of the commissioner. And I have a word-by-word account of the inquiry and address this matter. The issue of the payslip, I think, I don't say it's a silly request. Every request is important, but I've worked 40 years in personnel, in HR, and it's very important for employers on many occasions to verify what a person has been earning, and that should have no effect on the decision on pay parity. Thank you very much, Honourable Chair.
Thank you very much. I only hope, Honourable Mkhaliphi, you will just be able to pick up the questions of clarity and only respond to them for now. The other issues, as I've said, we will look on them as we move forward. Over to you, Mr. Mkhaliphi.
Thank you. Thank you, Chair.
Yes, Mr. Mkhaliphi, you may.
Thank you, Chair. Now, on the question of why is the onus of proof on the employer on discrimination matters, it's simple. The employer is the employer that if there's an allegation of discrimination, the employer must prove that there was no discrimination. That's an agreement that has been reached by all employers at NETLAC and all our parties. And it's not something that we're raising here, it's in the law. The law says that if there is an allegation of discrimination, the employee must just show that they are being discriminated. The employer has got to show that that discrimination is fair and reasonable. Therefore, but the employee has got to show that they are discriminated. Therefore, the employee will say, here's my pay slip, I'm being paid lesser than this person, here's this person's pay slip, that is discrimination. And then the law says, in that case, then the employer must show that that discrimination is fair and reasonable. Now, if Honorable Balken require the employees now to show that that discrimination was unfair, it's just putting too much onus on employees on that. The only thing the employees need to show is that there's a difference in what they are being paid and they believe that difference is discrimination, and the employer will have to prove that it's not discrimination, and that has worked. It has not been challenged in any court as is in terms of international best practice on that issue. On the issue of what's the definition of arbitrary ground, I mean, the courts have defined this. There's been many cases that interpret our legislation. Our legislation is good. Arbitrary ground is arbitrary ground. You can't define it. It's what it is. Anything that differentiates between me and the next person, and that differentiation is used to affect me, give me inferior service or inferior wages, and discriminate against me, that's the ground. You don't have to define it. We've had this discussion again at NETLEC. There was that question, whether should we define it? And we all agree that any arbitrary ground, as long as it's got the effect of discriminating against one worker against the other, it is a justifiable arbitrary ground that could be challenged. On the issue that Honorable Mkondo is asking about, how can these employees be supported and how are they supposed to be supported in these kind of cases? I think the issue is that these cases don't come to the department. They go to the CCMA. The law says if you've got a case on equal pay or discrimination, it goes to the CCMA, and then the CCMA hear the case. It does not come to the department. Therefore, there's no way that we can offer support because we do not know of these cases. We only know after they've been decided. If employees come and ask us can we assist them in formulating their case, this is their case, we can have that discussion with those employees. But unfortunately, in terms of the law, the cases of unfairness on discrimination and on equal pay go directly to the CCMA. And the issue of whether the white lady is being discriminated when she's earning less, again, we need to agree that in terms of the law, there's nothing wrong about discrimination. The law doesn't allow discrimination. It deals with unfair discrimination. The question is whether that discrimination is fair or not. My colleague Ntswaki now has gone through a whole length of what would make discrimination fair. If this black person who's earning more than the white lady has been there for a longer period, it could be a fair reason for having a different wage. And those are the issues that you look at when you deal with these issues. Therefore, if she wants to lay a case, she's got to be able to show that everything being equal, she's not getting the fair treatment. And on the question of whether are they doing the same job, yes, they were all doing the same job. They are all merchandisers. The complainant, Mr. McGovernor, was a merchandiser. Miss Smells, the white lady, was a merchandiser. And the person who's African male who's earning more was also a merchandiser. And there are, as I've said, different reasons why the black man is earning more, and there are different reasons why the white woman is earning more than Ms. McGovernor. In terms of the award, all of that, we have to go through the award, read the court judgment, what it says in terms of these issues, so that we can understand the case. Honorable Hendricks, we will look on the case of Pioneer Food. I'm not sure Pioneer Food and who, so that we can easily get the case, so that we can look at it and see what Judge Steenkamp says, because we're not going to be able to get the case by going through indexing it by Judge Steenkamp. We need to get the exact citation of the case. I know one of the parties is Pioneer Food. It might help if we can get Pioneer Food against who, then it will be easy to get a case and look at it, look at the case from the CCMA, look at the case at the Labour Court, what Judge Steenkamp said about it, and look on the issues that he's raising and see whether there are issues that he's raising that we need to look at. Thank you, Chair.
Thank you very much, Mr. Mkhalif. Thank you, members, for clarities that you have sorted. One thing that that I think is going to be important in moving forward is that we will have to because the author of the complaint indicated that he's intending to submit a proposed amendment. We can't then say he can't do that. It's within his constitutional right to do that, submit that to Parliament. I want to say that I think what is going to be important is for him to do that, bring it to us. He's got all the right to table it and to us. And then after that, we then take whatever decision in terms of processes that we want to undertake. And I think the Secretariat will then have to do that. And then we then see how then do we move forward. But like the reason for, and I think I want to repeat this, the reason for requesting the department to just take us through is because of some allegations. I would say it's allegations or some information that the matter was taken to the Constitutional Court, and I think that if you go through the correspondence that was sent to us, there is that, and it was important therefore for the office of the chair to first get clarity on that thing so that we don't get involved in a matter that the other state, the component of the state has dealt with that. We're all here. It is in the presentation of what then has happened. So we will write. The Secretariat will write to Mr. Makavana to submit, and then because we will have to engage and take it from there in moving forward. I think that's that, honorable members. We have it was the only item in our agenda for today, and I want to thank you very much. The one thing that I want to stress, please, so that we don't sit in here in meetings and find ourselves now that we are challenged somewhere when we have people that we don't know. In future, members must reflect, and guests must reflect that is Dundra, make an example, myself also, Dundra, ANC, making an example, Honorable Dana, Fiddle Front Plus, I think it's Honorable Mkonto, Honorable Picardo, Honorable Volmaras, Honorable Bonani, that are doing it correctly, so that we understand exactly who is here. I don't know whose Tiny Maria's iPad is. I don't know who's that person. But I think what we do in plenary, it's something we must also do here in committees. Having said that, thank you very much, honorable members. We will be informed in due course, depending on the information that will be awaiting from Mr. McGovern. Thank you very much. I think.
Thank you very much, Madam Chair. Thank you.
Our meeting is adjourned. Thank you.